Good afternoon. Welcome back to UCSF Medicine Grand Rounds. I'm Bob Wachter, Chair of the Department of Medicine. Today we're back to virtual because we have speakers from three different places, and appreciate you joining us today. Obviously, the issue of abortion and Roe versus Wade and the recent leak in Politico is profoundly unsettling and really sets us up in the next several months for a major decision that will come down from the Supreme Court that will influence healthcare, politics, policy, the law. It's really a dynamic time in our country, and one that's really deserving of our attention. And so we thought it would be useful to take a grand rounds and spend some time thinking about the potential implications of a change in the law and some of the legal issues, some of the medical issues, some of the societal issues, with three terrific speakers who will approach this from very different angles and very different expertise. The format here will be a couple of talks with slides, and then the rest will be largely a panel discussion. And when we get to that, we'd love to hear your questions as well. Please put them in the Q&A box. As usual, closed captioning is available, and as is CME credit. If you're interested in that, stay on at the end, and we will give you the address. Let me introduce the three speakers. The first is Radhika Rao, who is professor of law at UC Hastings College of the Law. Radhika graduated magna cum laude from Harvard Law School and served as Supreme Court editor of the Harvard Law Review. After graduation, she clerked for Justices Harry Blackmun and Thurgood Marshall at the Supreme Court. So she not only knows the law extraordinarily well, but has insider knowledge of how things work within that particular sausage factory. Professor Rao teaches and writes in the areas of constitutional law, comparative constitutional law, property, and the law of the human body. And she's written important articles on the issues that are relevant today, including abortion and assisted reproduction, gene patenting, and property rights within the human body. So Radhika, thank you so much for joining us today. The second speaker will be Eleanor Bimla Schwartz. Bimla is a general internist and health services researcher whose work centers on harm reduction and health promotion. Her particular interest is in areas of healthcare that relate to meeting the needs of diverse and vulnerable populations. She's had a wonderful, exceptional career after leaving UCSF, where she did her early training some time at the University of Pittsburgh, and then recent years at the University of California, Davis. She served as medical consultant for California's Office of Family Planning, senior medical expert in reproductive health for the VA, and a member of the FDA's Advisory Committee on Reproductive Health Drugs. We were thrilled to recruit her back to UCSF, I guess a year or two ago, to become chief of the Division of General Medicine at Zuckerberg San Francisco General. So Bimla, welcome, and lovely to have you on this panel. Thank you. And finally, also a welcome back to UCSF to Dr. Sunithya Williams, who's a physician at the Alabama Women's Wellness Center and joins us, I think, from Alabama. Thank you for being here today. Sunithya is a board-certified OBGYN physician and a fellowship-trained complex family planning specialist, and she did that fellowship, in fact, at UCSF. She practices in Huntsville, Alabama at the Alabama Women's Wellness Center and Alabama Women's Center for Reproductive Alternatives, where she offers full-spectrum reproductive health care, including the provision of abortion. She's a founding member of an organization called Centering Equity, Race, and Cultural Literacy in Family Planning, a group that works at the intersection of reproductive justice and anti-racism. And Sunithya, thank you for joining us today, and I look forward to hearing your comments. So format-wise, we're going to start with Radhika, who will give us a short talk on the legal perspectives. Bimla will do the same with a little bit more focus on some of the medical issues. And then we'll bring on Sunithya for a discussion of all four of us at the end. So let me hand it over to Radhika.
Thank you so much. Let me share my screen so that you can see my slides. And let's see. Okay, hopefully you're able to see my screen.
Yep,
yes?
Perfect.
Okay, so I am so delighted to be here. Thank you so much to Dr. Bob Wachter and all the rest of you at UCSF. And so let me start with this talk on Roe Dobbs and the future of reproductive rights and justice. So I thought I would start actually with the provisions of the Constitution, which are relevant here. And specifically, it's the 14th Amendment. The clause that we're really looking at here is the Due Process Clause, which provides that no state should deprive any person of their life, liberty, or property without due process of law. That has been held to incorporate these unenumerated rights that are part of the liberty that's protected against deprivation by the government without due process of law. Although many think that the Equal Protection Clause is also very relevant here, and that's another provision of the 14th Amendment, which says that no state can deny any person within its jurisdiction equal protection of the laws. Roe versus Wade, of course, is the seminal decision here, and it was authored by my old boss, Justice Harry Blackmun. In Roe, Texas had a law that made procuring an abortion a crime, except by medical advice for the purpose of saving the life of the mother. And the Supreme Court struck down that law almost half a century ago, in 1973, relying upon an unenumerated right to privacy that was grounded in the Due Process Clause of the 14th Amendment. The court in Roe said that although the Constitution doesn't explicitly mention any right of privacy, the court has recognized that there's an unenumerated right that's grounded in several different provisions of the Constitution, including the Due Process Clause of the 14th Amendment. Roe also is very famous for its medical framework, and this is because Justice Harry Blackmun himself, before he ever became a Supreme Court justice, was the general legal counsel for the Mayo Clinic in Rochester, Minnesota. So Justice Blackmun loved doctors and the practice of medicine, and he went back to Minnesota to do research on abortion before he ever authored the opinion in Roe. He came up with this trimester framework, which divided the 9 months of pregnancy into these 3 trimesters. And in Roe, the court set up this framework whereby in the first trimester, the government couldn't regulate abortion because the risks were less than those of childbirth. In the second trimester, the state's interest in protecting the health of the woman became compelling so that the government could regulate, but only to protect the health. And in the third trimester, the state's interest in protecting fetal life became compelling, so that at that point it was permissible for the government to prohibit abortion unless it was necessary to preserve the woman's life or health. That's the trimester framework, and it drew a critical line at viability, which was defined as the point at which the fetus has the capacity for meaningful life outside the womb. At that point, it was roughly 24 to 28 weeks, but now it's a little bit earlier, maybe as early as 20 weeks. According to the Supreme Court in Roe, this viability line has both logical and biological justifications. What are some of these justifications? We talk about this in my constitutional law class, but I think that you can think about them in 3 categories: philosophical justifications, medical justifications, as well as legal. Philosophically, the idea that the fetus could survive on its own seems to mark the earliest moment at which you could think of it as an independent entity, one which could have rights and interests independent of the woman. Medically, viability marks a point at which this, of course, it's a survival. So I've got a kind of a graph here from The Economist, and so it's a spectrum. But medically, I think the idea is that the fetus could be removed from the womb and still survive, albeit with assistance. And legally, this line roughly coincided with lines which were important in the early Anglo-American precedent. So Justice Blackmun drew a line that had numerous justifications, but that's the line that is currently at risk before the US Supreme Court. in Dobbs, this viability line. So that brings us to the question of personhood. Many states want to give personhood to the fetus and give it rights. But of course, according personhood status to the embryo or fetus really seems to diminish the status of the person who carries that embryo or fetus to a mere carrier. So the Supreme Court in Roe ruled that the fetus is not a person, a constitutional person protected under the Constitution. But many scholars have criticized that holding. And in fact, I can tell you that it was not there in the original draft of the opinion. Justice Blackmun confided to us, his law clerks, that when he originally drafted the majority opinion in Roe versus Wade, he did not include language to the effect that the fetus was not a person. He didn't think it was necessary. But one of the other justices, when he circulated his draft opinion, basically demanded that he include that language. And you want your draft opinion to have as much unanimity as possible. So he incorporated the language, and he was really severely criticized for it. Many scholars have argued that it would have been better for the court not to hold that the fetus is not a person, and that perhaps the court should have grounded the right to abortion in equal protection rather than in the due process clause. Justice R.B.G., Ruth Bader Ginsburg, was one of those who criticized Roe on this basis. And others, such as the law professor Kitty McKinnon, have argued that the right to privacy framing was wrong, that it reinforces inequality. But this equal protection theory was not argued to the court in Roe versus Wade, nor would it likely have been successful at that time, because just a year after Roe, the court decided a case called Geduldig against Aiello, in which it held that pregnancy discrimination is not sex discrimination. That brings me to Planned Parenthood against Casey. Almost 30 years ago, Roe was almost overturned in Planned Parenthood against Casey. But at the last minute, one justice flipped. One justice switched his vote, and that justice is Anthony Kennedy. Together with Justices O'Connor and Souter, they formed a triumvirate, 3 justices that decided to hold on to retain and reaffirm what they called the essential holding of Roe. What was the essential holding of Roe, according to the Casey court? The viability line. What was not the essential holding of Roe? The trimester framework. So they kicked out the trimester framework, and they replaced it with a new standard, the undue burden standard, under which only those laws which have the purpose or effect of imposing a substantial obstacle are unconstitutional. So that's Casey. And pursuant to the standard, the court upheld an informed consent requirement, a 24-hour waiting period, a parental consent provision, but it struck down a spousal notification provision. That's the only one the court found unconstitutional. That brings us to the latest, which is Dobbs, the leaked Supreme Court draft opinion in Dobbs against Jackson Women's Health, which the draft says is dated February of this year. Many questions raised, including who leaked the draft, right? And all of the news outlets are asking the question, cui bono, who stands to gain from the leak? There's speculation that it could have been a clerk or a liberal employee at the court because they were so upset and outraged by the draft opinion. There's also speculation that it could have been a conservative clerk or employee at the court. I hesitate to say justice because I don't think that any of these justices would want to leak such an opinion. But I've circled the justices so you can see which ones are considered to be in red. The conservatives, Justice Alito on the far left, who authored the draft opinion, Justice Kavanaugh, and Justice Clarence Thomas, Justice Gorsuch, and the latest Justice Amy Coney Barrett. Those are the 5 justices who form the majority in this draft opinion in Dobbs. Circled in blue are Justices Kagan, Breyer, and Sotomayor, the liberal justices who are dissenting, of course, I'm sure, in this case, if the majority opinion turns out to actually be the majority. And in purple, kind of in between, Chief Justice Roberts, who I think is looking for additional votes. So what would be the conservative reason for leaking? Perhaps Chief Justice Roberts is trying to get one of the justices to defect, and with him to retain and reaffirm Roe, just as happened in Planned Parenthood against Casey 30 years ago. I think that's a very plausible explanation for the leak. Briefly, ideological scores. I'm not going to go over this because I want to get to the bulk of this draft opinion in Dobbs. What does the draft opinion say? First of all, it skewers Roe versus Wade and the constitutional reasoning behind it. Justice Alito, in his draft opinion, mocks, really is just so caustic in his tone. He's mocking Roe and saying that its survey of history ranged from the constitutionally irrelevant to the plainly incorrect. He says that the court cataloged a wealth of information having no bearing on the meaning of the Constitution and concluded with a numbered set of rules, much like those that might be found in a statute enacted by a legislature. He's referring to the trimester framework, which I just explained to you. He says Roe was remarkably loose in its treatment of the constitutional text. It held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned in the Constitution. And he says Roe expressed the feeling that the 14th Amendment was the provision that did the work, but its message seemed to be that the abortion right could be found somewhere in the Constitution, and specifying its exact location was not of paramount importance. You get the drift. It's incredibly caustic, mocking, a really very unbalanced opinion, which is quite atypical. Majority opinions usually do not have this tone. Normally, only a dissent sounds so angry and bitter, but this opinion, which purports to be a majority opinion, really is quite unprecedented. What does the draft opinion actually do? Well, here's the most relevant language. The court says we hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause. That provision has been held to guarantee some rights that are not mentioned in the text of the Constitution, but any such right must be deeply rooted, he says, in the nation's history and tradition. So what are they saying? Abortion is not explicitly mentioned in the text of the Constitution. And even though it's been protected as precedent for the last almost 50 years, it's not deeply rooted, according to this opinion, not deeply rooted in the nation's history and tradition. The court says it's time to heed the Constitution and return the issue of abortion to the people's elected representatives, that this is to be resolved by the states, by the people voting. That's the ultimate conclusion. So what does this mean? Well, if the draft opinion actually becomes the majority opinion, then 26 states are poised or likely to ban abortion, according to the Guttmacher Institute. Here's one map. And this is from the Center for Reproductive Law and Policy. We'll see a patchwork of state laws, with the blue states enacting laws that permit abortion and that protect women's rights, red states passing laws that prohibit abortion. Some of them are even passing laws or trying to that would prevent women from traveling or prevent pregnant people from traveling out of state to have abortions elsewhere. It's a return to a history that is unimaginable today in 2022. What else does the draft opinion portend for the future? Well, Justice Alito attempts to confine abortion. And he says Roe's defenders characterize the abortion right as similar to these other rights that were recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage. But he says abortion is fundamentally different because it destroys what those decisions called fetal life and what the law before us, the Mississippi law in Dobbs, describes as an unborn human being. However, do not believe Justice Alito or the draft opinion. The logic of the draft opinion cannot be confined to abortion. It also reaches, at the very least, contraception, at least those methods of contraception that apply post-fertilization to prevent implantation of the embryo. So if the state wants to define life as beginning at conception, then presumably those methods of contraception could be deemed illegal, and no constitutional right would stand in the way once you've struck down Roe. It may also apply to other rights that are not explicitly mentioned in the text or deeply rooted in history and tradition, such as the right to same-sex marriage. So what does this draft opinion portend for the future? I think the future looks ominous. If this ends up being the majority opinion, Obergefell is a very recent precedent. 2015, the court upheld the right to marriage equality. That may be on the chopping block too. And that concludes my rather dire predictions and presentation for today. Thank you.
Thank you for, yes, really fascinating, depressing, comprehensive review of where things stand and might stand as we go forward. Lots of questions, but we'll hold them. Let me turn it over to Bimla and look forward to hearing your comments.
All right. So thank you for this opportunity to clarify the ways in which I would expect changes in the legality of abortion to have profound impacts on healthcare for the underserved in this country. Just to be clear, I have no financial relationships with any pharmaceutical companies. I recognize that some who seek abortion services do not identify as women, and that gender, sex, and family planning are inherently complex topics. My objectives for this time is to review for you options for pregnancy termination and to share with you the existing evidence and state of the science, which is very clear on the health consequences of turning away patients when they come seeking abortions. I want to share with you a bit of my own journey in understanding these things and say that when I started here at UCSF, I was actually quite ignorant about a lot of things. I had seen people wearing buttons showing this image of a crossed out hanger, but I have to admit, I didn't actually know what it was about. I thought perhaps these were people protesting dry cleaning, which I believe involves a fair number of environmental toxins. And then one day, many decades after Roe was legalizing abortion here in what is thought to be very liberal San Francisco, when I was on my OB-GYN rotation at Parnassus, I had the opportunity to meet a woman who came into the emergency department with a piece of metal in her cervix. And in a painful and dangerous effort to free herself from the shame of an undesired pregnancy, she had unwound a clothes hanger, and it did not go well. And so on the screen here is a link to a brief but powerful documentary titled When Abortion Was Illegal, which I highly recommend to any of you who are unfamiliar with this clinical history, as I myself once was. This for me was a highly educational clinical encounter, and I would say it left me with a profound appreciation for the ways in which stigma and silence result in shame, which really kills people. And it made me appreciate that we have to stop judging if we want to truly be able to start healing our community. And over the years, I've come to view abortion care as really part of the spectrum of palliative care, and like all end-of-life care, as sacred work. I take the 10 Commandments seriously, and I feel we have an ethical obligation to help our patients understand how to safely manage an undesired pregnancy. As this cartoon highlights, abortion restrictions disproportionately affect poor families, meaning changes in the legality of abortion will have a profound impact on healthcare for underserved populations. As this graph shows in blue, rates of unintended pregnancy are considerably higher among those living below the federal poverty level than those living at or above 200% of the poverty level shown here in yellow. Families seek abortions when they don't have the resources required to support another child. And because of all the ways that racism has impacted generational wealth in this country, families of color, shown here in red and yellow, more frequently find they do not have the resources required to support a children than white families, shown here in blue. And this is unfortunately a very common experience. When I started my medical training 25 years ago, it was estimated that half of US women had an abortion at some point in their lives. With the success of efforts to increase access to highly effective contraceptives, rates of undesired pregnancy have decreased considerably. And today it's estimated that 1 in 4 US women will have an abortion before the end of her reproductive life. Nonetheless, that means that abortion is twice as common as breast cancer. And if we got rid of the stigma, the marches of all the families impacted by abortion would be twice as large as those shown in the picture here of breast cancer survivors. Taking us down a quick refresher on what we're talking about when we're talking about pregnancy options, we need to remember that sperm remain viable in a woman's reproductive tract for up to 5 days. So this is the 5 days when our emergency contraceptive products are relevant. And women are only fertile for a few days every month, approximately 2 weeks after the last menstrual period. And as this figure shows, we know fertilization occurs in the fallopian tube, and then over the next week or so, that fertilized egg moves to the uterus, and implantation occurs, producing HCG, which is what our pregnancy tests measure. So at 4 weeks from her last menstrual period, assuming she has regular cycles, she would miss her first period, and a test might be able to tell her she was pregnant. For the first 10 weeks of pregnancy, we have the option of using abortion pills according to the Food and Drug Administration, although there is data showing that these pills are useful on beyond 10 weeks, which is why that asterisk is there. There's also the option of conducting a quick office-based procedure early in pregnancy. Until the point in viability, which, as Dr. Rao highlights, can vary from state to state based on regulations, more complex surgical techniques are required to end a pregnancy. And then at 36 to 40 weeks, women typically give birth and then would have the option of placing that pregnancy for adoption or parenting. But currently 80% of US abortions occur before 10 weeks when pills are an option. And if access to abortion services was easier, there would likely be far fewer later abortions. For those who are wondering what it looks like when a woman uses abortion pills, this is what early pregnancy tissue looks like, scaled against common coins. Really, the experience is equivalent to that of an early miscarriage, or for most women with a heavy period. These are the tools of the trade, pills that can be swallowed and don't result in any more choking than usual pills. Taken at home, result in about 5 hours of cramping and passing the pregnancy, or tools that can be used in an office to conduct a procedure that usually takes about 5 minutes. When we're talking about abortion pills, we are not talking about emergency contraceptive pills or those over-the-counter pills, sometimes called Plan B. Those pills delay ovulation until the sperm run out of energy. These pills do not cause abortion. Abortion pills, sometimes referred to as Plan C, are mifepristone, a 200 milligram tablet that is very highly regulated, but is available by mail order from certified pharmacies. And then misoprostol, which is what causes the uterus to contract, and that's 4 tablets of this medication that was initially developed to try to protect the gastric lining. Usually the cramping involved in use of these pills can be managed with ibuprofen. For those who want to learn more, I would refer you to these 2 websites. One is a CME program that can give you an hour of CME credit. And then for people who are looking to get mail order pills, plancpills.org. This is what that online CME training looks like. You can watch 3 quick video clips that will model for you the counseling that would be involved and let you double check that you've absorbed enough that you could share this effectively with a patient. Really, this is well within the scope of any clinician who comfortably manages medications. It involves counseling patients order pills, and no need to do a pelvic exam, an ultrasound, or any procedural training. And it is very possible to safely and effectively provide these pills using telehealth. In terms of the state of the science on what happens when women seeking abortions get turned away, I want to highlight the work of one of our fabulous UCSF colleagues, Dr. Diana Green Foster, who studied over the course of 10 years, lots and lots of women and what happened when they either received the services they requested when they came to clinic or they were turned away. Initially, this study was designed to try to understand what was going on with mental health and family well-being. I had the opportunity to partner with them and look at some of the physical health consequences. And the study also provides some important information about the socioeconomic outcomes of families deprived abortion services. Briefly, 231 women showed up to clinics just above the gestational limit for that clinic, and so they were turned away. 452 women got there just underneath the clinic's limit for service provision. And then 273 women were enrolled who were seeking first trimester abortions, because that is when most women in this country seek abortion services. They recruited from 30 sites across the country, one which may look somewhat familiar on this map. And all of these were in places where they were at least 150 miles away from the closest abortion provider providing services beyond that type. And this is a map that gives you a sense of what access to services currently look like in this country. The reasons women said they were seeking abortions in the Turnaway study are similar to those that have been reported in other studies. The number one reason was that families were not financially prepared for another baby at this time. When they looked at the mental health consequences with our colleague Antonia Biggs, they found that there was no difference in depressive symptoms among those who obtained a near-limit abortion, shown in dark gray, or those who were turned away and had to give birth, shown here in green. When they asked whether women had regrets after seeking abortion, the answer was really no. 99% of participants reported that abortion was the right decision for them at all time points over 3 years of follow-up. And women who were denied abortions ended up reporting more regrets than those who had the abortions they sought. Of those denied adoptions who gave birth, only 9% pursued adoption. And women who placed a child for adoption were much more likely than those who parented to say they still wish they could have had the abortion. When we looked at the physical health effects, we saw that there were significant differences both in the number of days that physical activity was limited, as well as in the number who experienced a potentially life-threatening condition. When we looked at self-related poor health over 5 years, you can see in green here, those who gave birth ended up with the highest rates of poor health being self-reported over 5 years, while those with first trimester abortions, as is most commonly obtained in this country, had the lowest self-rated health over the next 5 years. Despite the counseling that is mandated in some states, it's really important to recognize that abortion has no adverse effects on mental health, on risks of breast cancer, on subsequent drug use, or on future fertility. What we did see from this Turnaway study was that there was large differences in poverty. Over the 5 years of this study, children whose mothers received an abortion were much less likely to end up living in poverty than children whose mothers carried an unwanted pregnancy to term. Importantly, over the course of the study, families didn't actually end up with more or fewer children. Those who felt that this pregnancy wasn't at the right time, in many cases, did go on to have a pregnancy that they carried to term later in the study, but those families were less likely to raise those children in poverty. Perhaps the scariest part of the Turnaway study for me is the number of deaths that were noted among the 1,132 study participants. There were 8 deaths 4 among women who gave birth after being turned away when they requested an abortion, 2 of which were classified as maternal deaths. And there were 4 among the second trimester abortion patients, but none of those were related to pregnancy. There were no deaths among those seeking first trimester abortions. When we look at the comparative safety of abortion, we see that the annual death rate per 100,000 of being struck by lightning is about the same as ending a pregnancy before 8 weeks. That goes up with increasing gestation. However, at all times, terminating a pregnancy is less risk to a mother's life than carrying that pregnancy to term. And what we see from the Turnaway study is that women who are seeking abortion services and tell you they cannot be pregnant right now, really cannot be pregnant right now, and have a much greater risk of death if they carry that pregnancy to term than we see in the general population. We need to be mindful of this within our global epidemic of maternal mortality, where the US is having a distinguished role at the top of the charts in ways that really are embarrassing. And to be aware that what we're doing in California really is different than what's being done in many other places in the country, and that California's investment in family planning services needs to be credited, at least in part, with the fact that maternal mortality in California has followed a very different trajectory than what is seen in the rest of the country. So with that, I'd be happy to open it up to questions with the rest of the panel and just remind us all that reproductive justice involves many, many things. And
Thank you, Bimla.
I can
Really
stop
appreciate
sharing.
that.
There you go.
Thank you. Very, very instructive. Thank you. Why don't we bring on Sunithya and give you an opportunity to tell us a little bit about your practice, what you're feeling these days, and any reactions you have to the 2 talks you've heard so far.
Yeah, so just to give a little bit of brief background, first of all, I really appreciate you all having me and giving me the opportunity to kind of talk about some of my experiences, not working in a place right now where abortion will likely be protected. So just to give you some background, I am currently an OBGYN and abortion provider in Huntsville, Alabama. I have worked and done abortion care in Missouri, Northern California, Mississippi, and now Alabama. And so I've kind of seen, had the opportunity to kind of give care in places where the restrictions were very different. And I think, you know, at this particular juncture in time, the people who are working in my clinic and some of the patients that are coming through are, everyone is, I think, on edge because we kind of know what's going to happen, but it's sort of waiting for that other shoe to drop. I think in thinking about the presentations that Dr. Rowe and Dr. Swartz gave, the thing that's really important to remember is that Rowe was never really enough. While certainly it will make a huge difference, right? The ability to be able to access some version of safe and legal abortion, not having that in the state of Alabama potentially will make a huge difference. But we already know that for so many people across the South, they had difficulty accessing care, right? I mean, certainly over the last 6 to 7 months since SB 8 has been in effect in Texas, we see patients from as far as Texas coming to Alabama. Certainly the majority of patients in Texas are going to New Mexico and Oklahoma, and clinics in those places are really at or beyond capacity. And so people are seeking care elsewhere. I took care of someone a few weeks ago who came from Dallas, I want to say, who drove to Louisiana to a clinic and couldn't get the appointment that she thought she had, so kept driving to Mississippi and was beyond the limit that was available at the Jackson Clinic. And so then kept driving and came to Huntsville. And that's a approximately a 12-hour drive. She left on a Sunday night and I was seeing her on Friday. And so if you think about sort of all of the logistical steps that involves, there are so many people, especially when you think about the fact that lower income people are more likely to be accessing abortion care services because of barriers to access of reproductive health care in general. So few people are going to be able to make those types of trips. If we think about the places that are closest to us, probably is going to be Southern Illinois in terms of knowing for certain a place that abortion is going to be protected. And that's at least 5 to 6 hour drive. So, you know, many people have talked about, you know, who is going to actually lose access to abortion. And certainly there will be people who have the resources, the financial resources to travel to other states, to travel to California or Illinois or New York to be able to get access to care. And there are other people who maybe don't have those resources, but have some of the knowledge and technical resources to self-manage their abortion. But there will certainly be a third group of people who don't have either of those. And they will continue their pregnancy to term. And especially, you know, as Dr. Schwartz mentioned, maternal mortality is an important part of that, right? We're in a place where we have the third worst maternal mortality in the country. And particularly for Black women, it is even exceedingly worse. And so that is not a small thing to kind of think about in the greater picture of like what all of this means on a day-to-day level for people's lives. But I want to open it up to questions because I think that is probably the biggest piece. So thank you.
Great. Thank you. Thank you. So let's bring everybody on and stick with you for a second, Sunithya. When you see a woman who is seeking an abortion, how do you decide on medical versus procedure, pills versus procedure?
Yeah. So for the large part, it's patient preference. Obviously, it is dictated by gestational age, and while there is data that supports going beyond 10 weeks for medication abortion, it's not something that we offer here in Alabama because of some of the restrictions. So that has something to do with, that's like the largest piece. There are very few medical contraindications to medication abortion. Certainly people who have like very severe anemia, I would be more likely to recommend procedural abortion. But wholly, it really is a personal decision on, you know, what the person has in terms of capacity, their capacity to follow up, what they think they can handle.
And if this decision goes through as in the draft report, what do you anticipate will happen if a woman comes to see you and you are, I mean, will you have any capacity, do you believe, and this is obviously a question for Radhika as well in terms of what the law says, to do either medication or procedural abortion or any kind of abortion will be outlawed? And then do you anticipate that you will be able to counsel a woman that you could go to Illinois and get it? Or do you think that other restrictions about that will come down the pike and put you at risk if you counsel a patient about that?
Yeah. So I have no hesitation to think that there's the potential for me to be criminalized for doing abortion in the state of Alabama. There, you know, in terms of like what the law actually looks like, if Roe is overturned, there is a pre-Roe ban that's on the books in Alabama. We don't actually have a trigger law, but then we also have a 2019 total ban on abortion, essentially, that did have criminal portions to providers. So that would not be something that I would be able to offer in the state of Alabama. My hope is that there would not be anything that came down in terms of limitations on being able to counsel people about other options. So counsel people about self-managed abortion, counsel people about other in-person abortion care services that may be in other states. From a First Amendment perspective, I would hope that would not be something that would hold up in the courts, particularly because we wouldn't be getting, like I personally am not getting state dollars or anything like that. But there are, you know, there's precedents for people who provide abortion being put out of the provider pool for Medicaid, right? And I do full spectrum OBGYN, so I deliver babies. I do prenatal care. A large portion of our patient population are Medicaid. And so is that potential there? Absolutely.
Yeah. So Radhika, when you take that sort of, how do you think this is likely to play out legally for someone like Sunithya in her practice in Alabama, seeing a woman in the clinic and figuring out what she can and can't do?
Excellent question. And actually, Dr. Williams, you seem very knowledgeable with the law, and the lines that you drew were perfectly apt. So basically, if Roe is overturned, there's no constitutional right to an abortion, then states can choose to do whatever they want. We're going to see a patchwork of laws like the ones that the Guttmacher Institute and the Center for Reproductive Rights for Law and Policy, that's one of our anonymous attendees, I wanted to link to that map as well. It's a really great map that is a wonderful resource. So if her state, if Alabama makes it a crime to perform an abortion, then it's going to be illegal for doctors in the state. Now, of course, hopefully the law will not prevent her from providing medical advice. But as she said, there is precedent. The Supreme Court upheld in a case called Rust against Sullivan, a provision of federal law that was known as the gag rule, colloquially, which basically prohibited doctors who were obtaining, or clinics that obtained any federal funds from providing, quote, abortion counseling. In fact, they were instructed upon direct request by a patient to say, quote, abortion is not an appropriate method of family planning. And that's all they could say. That was the script that the federal government required. And that was challenged as a violation of First Amendment rights. And the Supreme Court, in a case called Rust v. Sullivan, back in 1991, I think it was, upheld that law as constitutional. So that's the precedent that we have. So if you're looking at any federal subsidy, any federal funding, and practically every hospital in the country, we recently saw this under the Trump administration with their religious kind of rules. Any hospital that receives any funds, any physician who accepts Medicare patients would be subject to these kinds of restrictions, and that's constitutional.
So, Radhika, one of the questions from our viewers was, what is the likelihood that states will be able to restrict women from traveling to obtaining abortions from other states? And maybe take that and run with it in terms of the telemedicine options, you drive across state lines and go to a pharmacy and pick up your pills there, all the things that might say that Radhika is not able to provide it, but a patient on his or her own, in this case, decides to get information and tries to obtain an abortion outside of
Really great question.
Yeah.
I have my research assistants working on this right now because the current law suggests that individuals have a constitutional right to travel. But the problem is that that right to travel is nowhere explicitly mentioned in the text of the Constitution either. So for a court like this one, where they are so stingy about protecting constitutional rights and freedoms that have long been held dear, it's possible that they would ignore or flout those precedents. So to me, that's very frightening. But so currently, under current precedent, and there was actually a companion case to Roe versus Wade called Doe against Bolton involving a Georgia law. Now it was the other way around. Georgia wanted to impose restrictions on people coming into the state to have abortions. So it wasn't prohibiting people from going out of the state. It was saying you can't come into our state unless you're a resident. We're going to limit abortions to people who've been residents for more than 30 days or whatever. But the Supreme Court struck that down back in the companion case to Roe versus Wade, back in 1973. However, during the pandemic, a lot of states were refusing were getting rid of abortion services. And one of my colleagues has written an article about this. So there are some kinds of exceptions and loopholes, and there's also a possibility of this court interpreting those precedents narrowly to not protect a right to travel. So some of this is not exactly clear.
Yeah. And then another question that came in, that sort of, I'll give a version of it, which is, all right, so the woman, there may be restrictions on ability to travel. Does the decision by the Supreme Court do anything to a provider in California who wants to continue to provide abortions for, let's say, a woman coming from a state where there's a restriction, or would that require a California law or a new federal law that would somehow compromise the ability of a provider in a state that allows abortion to provide one on an out-of-state woman?
Well, Roe doesn't say anything. I mean, Dobbs wouldn't say anything about that. So in a sense, it would leave open the question of each state can establish its own laws. The problem here is that states like Texas not only want to criminalize abortion within the state, they want to criminalize anybody who aids or abets someone to get an abortion, a Texas resident. So if the Uber driver, right, or the Lyft driver under SB 8's bounty hunter provisions, anybody in the state of Texas can sue anybody who's involved, including a physician out of state who is aiding or abetting. Of course, the constitutionality of that law is still in question. So we don't know yet whether or not physicians here could be held liable. I was on a panel last week at Hastings that was sponsored by our consortium with UCSF Medical School. And the director of our consortium actually did a presentation in which she suggested, she was advising pregnant people who want medication abortions, if for some reason you need to go afterwards to the hospital, don't say it. You just say you had a miscarriage. Medically, they can't tell the difference because otherwise they could prosecute you. So when you go to the hospital, don't say why you've had a miscarriage. Just say you're miscarrying. Nobody needs to know. And by the way, anyone that you confide this information to under these kinds of bounty hunter laws could be an informant.
Wow. Emily, you talked about maternal mortality. Is there anything known about the outcomes of the kids who were born out of pregnancies that the woman would have tried to abort and couldn't?
Yeah, I think mostly it's about the ways in which the resources were available to that whole family. So a whole bunch of measures of childhood deprivation were less favorable for those children who came into the world at a time that their parents felt like they weren't ready to take them on. And I think one other point to maybe highlight that we haven't spent as much of a time talking about is that most people, the majority of people seeking abortion services actually already have at least one child. So it's not that they don't understand what is involved in managing another child. And I think to me, that's the most heartbreaking part of Sunithia's story about people with limited resources spending a week on the road trying to get healthcare is like, what's going on with their kids? Who's the babysitter that's got to watch the kids that they already have? Or do they have those kids in the back seat as they're trying to drive across the country for a week to get the care they need?
You made the point that it was sort of almost the iconic woman in the ER with the coat hanger that got you interested in the first place. Does the availability of abortion pills change the dynamic of this in any way? Is this sort of a less draconian future if the ruling goes the way the draft shows because of pills in some way, or do you think it's not really?
I absolutely hope that it will be. However, that is only to the extent that women actually know that that option exists. It is only to the extent that we, as their trusted sources of healthcare information, share with them that if you ever end up in a situation when you're pregnant and you feel you can't be, there are pills that you can use to help end that pregnancy. And I'm happy to help you get those pills. They're available on the internet. They're easy to mail. Yes, it should be a very different world, but I think the thing that has really stuck with me over the years is the ways in which people in desperate circumstances who feel like their options are limited sometimes do really potentially disturbing things. I would say I practiced in Pennsylvania for a while where state resources were not available the way they are here in California, and having to tell people who came saying they couldn't be pregnant right now, that they would have to come up with the cash to end that pregnancy. And when we're saying come up with the cash, it's usually at least $500. And not that many people have that amount of money just sitting around. And you would just see in people's eyes, like they were going to go do some crazy stuff to come up with cash. And that's a really, really difficult thing to have to watch.
Yeah, I think just sorry to add on to that. I think that really ties together the 2 points that have been made by Dr. Rao and Dr. Schwartz about the idea of Dr. Rao was mentioning telling people that you don't have to talk about the fact that you're having an abortion if you are in the emergency room. And that's something I've been counseling my patients on since I was in Missouri, just because not even from a criminalization standpoint, but from just the stigma and, concerns about being judged, that sort of thing. But certainly thinking about, absolutely, I think that, sorry, excuse me. I think that absolutely the availability of medication abortion is going to change what the landscape will look like in comparison to pre-Roe times. But the bigger concern is about the risk of criminalization. That we're already seeing people whose pregnancy outcomes have been criminalized, people who show up having a miscarriage and it's been presumed that they have self-managed their abortion and being arrested. That happened recently in Texas. There have been many women in Alabama who've been criminalized for not necessarily abortion, but other pregnancy-related things that I could go into the details of, but it really is horrific. And so that is also a part as healthcare providers for us to remember that that is not our job. Our job is not to police people. Our job is not necessarily, there is no mandated reporting about self-managed abortion. And that's the bigger risk that I think people are at when they are self-managing their abortion.
Yeah. One of the viewers asked, what do you think happens to training for OBGYN residents in this world, particularly in their training in a state like yours?
It is going to stop.
They just won't learn anything about doing abortions during their training.
Not really. We right now receive residents from the University of Alabama in Birmingham as their training site for their Ryan residency training program. And, based on discussion with them and some of the program director there really is very little exposure at the actual hospital. So pretty much all parts of the training that they have is didactic, and then the training that they do with us. And so certainly it is something that many people have talked about in terms of recruiting medical professionals to come to a state, recruiting residents to come to programs. What is the impact on those things going to be for all of these places where the restrictions are going to be so significant? Yeah.
We only have time for a couple more. Radhika, I can't leave you without a few inside baseball questions. So you made the point that Alito's drafting was sort of unusually aggressive and nasty. I assume that's intentional. And why would he feel that is necessary to overcome sort of the burden of stare decisis, and that if you're not really harpooning Roe versus Wade, you haven't reached the threshold to be able to knock out the precedent?
Maybe that's part of it. I also think it's really partly his personality. Sad to say that he can be incredibly caustic. And the inside baseball story is, why is he writing this opinion? If the chief were in the majority, he would never have signed it, because the senior justice in the majority has the power to determine who writes the opinion. So the chief would have assigned it to himself, or he would have assigned it to somebody that's more moderate, like Kavanaugh.
Yeah. And on the sort of further inside baseball, in the process of drafting, is it usually that the first draft might be a little bit sort of out there and it gets sanded down over the course of redrafts, or what sort of is the usual process of going from a fairly early draft to the final?
Yes, definitely drafts change. So you circulate your original draft. And as I said, in Roe versus Wade itself, Justice Harry Blackmun had not incorporated the language that a fetus was not a constitutional person. But Justice Potter Stewart asked him explicitly, he said, I will sign on to your opinion only if you put in that the fetus is not a person, because I think it is necessary for the court to answer that question in order to protect the right to terminate a pregnancy. Justice Blackmun didn't think it was necessary. So too here, the other justices who were part of the majority would give suggestions, and Alito would respond to those suggestions, and the ultimate draft would presumably be different. So it's really amazing that we are actually seeing, as you said, the sausage making process. In the process of being made, the ugly process, we're seeing this initial draft.
And maybe the last question, we've got to go in a sec. It sounds like you sat at the knee of Justice Blackmun. I'm sure the other justices. I'm sure question one is, tell us about Roe versus Wade and how it went. Did he understand the implications of it? Did he understand that this would be talked about 50 or 100 years from now, and anything about it, its course, that he saw that surprised him?
Wow. So he said that the court had no clue how controversial it was. I think he might have recognized it. And the reason for that is there's a little known history to Roe versus Wade. Actually, the first time that Roe came up was the year before. And there were 2 justices short because 2 justices had just recently died or retired. So you had a court of only 7 justices. So Chief Justice Berger, Blackmun told me this inside story, appointed a screening committee of 3 justices to take only, quote, non-controversial cases because they were a short court. One of the non-controversial cases they selected was Roe.
Wow.
So they had no clue. But then Justice Blackmun said that Berger assigned to him the task of drafting a memo in this case. And he authored a memo that recommended that they should hold the case over for re-argument the following year, because he thought that you could not issue an opinion in a case of this significance with just 7 justices, because it could go the other way. He said some of the other justices didn't agree, but ultimately he prevailed. And that's why he knew that the case was coming up the next year. So he went back to Rochester, Minnesota. This was his first summer, junior justice on the Supreme Court. Holed himself up in the medical library and read absolutely every book he could about abortion, the Hippocratic Oath, viability, trimesters, all of that medical knowledge he infused into the opinion, with what results you can see how much it was criticized. But he loved doctors. He loved physicians. He loved the practice of medicine, and he loved UCSF. By the way, one of his great moments was when he was invited to do grand rounds at UCSF. He told us about that. So I am so privileged to be here with you.
Thank you. Well, that's a lovely way to end this. So incredibly interesting, troubling. You've taught us a lot, and we'll have to see how it goes. And I think it's important. This is a time for activism as well, for not just to talk about stuff, but to do stuff that we can do to make things better for our patients and for healthcare in general. Thank you all for doing this. Really grateful.